before the end of the
Program.
internship period. Yes. So somebody will be coming to talk on alternative dispute resolution, as you really, that's from a WIPO perspective, that's World Intellectual Property Organization and all that. And then
Okay.
somebody would come and talk on patent drafting. Somebody would be coming to talk on just different, someone
Yeah.
will be coming to talk on fashion law. Someone else was supposed to come to talk on cyber law, but it's like she's a bit busy. So I'll look for someone else that can come and talk on cyber law. But I realized that we didn't really show up for sports law. Is it that we don't really enjoy sports law? So that if we don't like a particular area, we'll not bother getting resource persons from those places. What do we think?
I actually enjoyed the session. I showed up, so I don't
Okay,
know.
okay.
Yeah.
Those of us that missed it, has anybody gone to watch the session on sports law? You're welcome, Mr. Marx. Thank you for coming. Thank you for joining us. We'll be starting shortly. I was just
Okay,
trying
thank
to
you.
get their responses for some of the programs that we have coming up.
Okay, that's perfect. That's fine with me.
Okay. So are we okay with some of the topics that I have mentioned, that I have people coming to speak on? So I have somebody that will be coming to talk on how to file your proceedings in courts. That's if you have IP infringement issues for your clients, how to draft your claims, how to write your opinions,
Wow.
etc. So I have somebody that will be coming to talk on that one of these days. And then another day, somebody will be talking on fashion law. We'll also have somebody, hopefully I will get somebody on that cyber IP thing. And then there's also somebody for the ADR from a WIPO perspective, and then there's patents drafting too. So these are the things I have. So for the days that we'll have these people come to present, we might not need to submit um, assignments on those days. We'll just come listen and then we'll ask questions and try to engage with them. So I'll be sending us the flyers before time so that we can prepare our questions. So
Okay.
let's just start. Since everybody's here, I guess that this Infinix here should be Christina, probably. So we have Christina, Bernice, Clarice, Michelle. The people that are not here are Tony and Tolu. So let's start with Bernice.
Hello. Good evening, everybody.
Good evening.
So my report for this week was is on intellectual property and the fashion industry. So I had an idea of what I wanted to write. It was basically an argument or I was basically talking about the need for a new framework for the fashion industry. But when I made my presentation last upper week, Mr. Folarin pointed out that there is an existing, although not exhaustive, there is an existing framework, that's intellectual property laws that guide the Nigerian fashion industry. That he just made me see that instead of writing or going jurisprudential about my report, I should actually probably look at the existing laws and talk on that particular area. And that's what I did this week. I talked about the fact that there are no there's no special or specific framework for the fashion industry, but the we have copyrights, industrial designs, and trademark, also patents that governs intellectual property under the fashion industry. I talked about how fashion illustration by fashion designers can be protected under copyright law. But the major default that it has is that the fact that those fashion illustration are supposed to be multiplied, because most of the time they are not custom made. They are not made for just one person. They are supposed to be capable of industrial applications, that it will be multiplied in 1,000 folds. It will not be able to, the copyright cannot protect it that way, because one of the elements or one of the things you have to prove under copyright to be entitled to copyright is that it's a new product, or it's a new product. But when you do, when a work is multiplied like that, you cannot prove that each of them is actually new. So the copyright law is limited in that area. The second law that governs the fashion industry is the industrial design and patent laws. Industrial designs also protects the fashion industry through laws that kick against counterfeiting and knockoff. To get protected under industrial design, it has to be a new work, it has to be novel, it has to be also of industrial application. But the problem is that we have here is that
Yes,
hello?
we can hear you. Continue.
Okay, yes, the problem is with industrial design and patent is that for patent, it is very expensive for fashion designers to go. It's always used when you have innovative technology or invention. So using it for a fashion industry, for the fashion industry, that the fashion designer does not really have enough capacity to do that, will be making the fashion business run at a loss. And the standard of proving what is novel is very, very high, that a lot of fashion designers cannot necessarily reach. For under the industrial design also, for a work to be novel, it means that it has not been showcased or seen in the public. But we see that most of the time fashion designers hold fashion before they make their clothes in multiple folds. They have to do like a fashion show that they bring you to see, test the acceptability of the particular design and all of that. So that knocks out the criteria of being new and not being introduced in the public. Then the most potent is trademark, because it doesn't really have to do with the product, but it has to do with the brand per se. It has to do with the symbol, the logo, and the name. So, but most of the time, a lot of fashion designers are already selling even before they register a business name, even before they register trademark. So sometimes you have where the name has already been in existence, maybe the logo has already been trademarked by other people. So it always brings up a lot of problem for fashion designers and creative. So in short, we still need better laws for the administration in the fashion industry. Basically, that's all for my presentation.
Okay. Thank you very much, Dennis.
Yes, yes, ma'am.
So I think that listening to Mr. Folari's advice last week, or I think upper week, was really good. That's to look at the existing laws and then to try to pick out things that are applicable to the fashion industry. So when you first started the discussion, you spoke about copyright, and then you
Yes,
said that copyright is that the work has to be new and all that.
yeah,
So generally, when you look at the things that that's the criteria, new, yes, but they used to say I think that it should be original,
yes,
then it should be put in
original.
a fixed form and all that. But you know that when you are registering a copyright, nobody actually check what you are registering actually, to now run a search on it to know if it's original and if it's not original. And once it's put in a fixed form and it's tangible, they just allow um once
Hello?
you've hello.
Yes, yes, ma. I went
Yes.
off for a bit. Yes, yes.
Okay, so I was talking about the copyright that you
Yes.
mentioned, and I was like, part of the things that they used to require is that it's fixed and it's
It
original or
has to
something like
be
that.
original. Yeah.
Yes, but when you are doing the registration, and registration is not compulsory, but if you want to go ahead to do the registration, one of the things that I know here in Nigeria for registration is they don't conduct any search to know if what you are submitting is original or if it's not original. They will just
Okay.
allow you to put in your registration. So there is no way to check if what you're putting is original or not. There was a case that I saw on
Wow.
LinkedIn, and it was a fashion case about a particular print design. So I think I've forgotten the parties, but one of them had like a particular print which they went to the copyright for, and the other person too had something similar. But the issue that they had in that case was, you know, that you can actually go and do the copyright for a single work, or you can go
Yeah.
and do the copyright for a collection of works. So
Yeah.
what these people did was that maybe if they have 10 different designs that they want to release in a period of maybe 3 years, to now save costs, they now went ahead to register those
All of
10
them.
in a
Yeah.
single collection. And
Yeah.
when you're doing the registration for a collection, they will just ask you a simple question: what is the year for the publishing? That's what year was this work published? And so let's say they are doing the registration in 2021. They just put 2021, but those works were released different years. And so the other people who did it, maybe I'll share the link to the case so we can just go ahead to read it. The other
Okay,
people
ma'am.
who actually did the registration now took them to court that um, that that print was infringing on their own print, and that it's possible that that particular thing was not even released at that point, because to save cost they now put everything as a collection. So that was like false information and all that. But one thing is for sure, that copyright can be used to protect fashion, fashion wares and everything. And
Yeah.
then for industrial design protection, maybe you can also try to check if there is a grace period for, because I know for patents they might say, okay, within this period to this period, even if sh- um, you have gone ahead to have an exhibition, if you are still able to protect it within this period, you you can still have the protection. And then if you are coming under the Paris Convention, I think you have like a 12, the protection. Okay, no, that's for patent. But for this industrial design, currently I know someone who is interested in doing a registration for the patent design, but he's so scared to even bring out the, what they call it, the sample that he's supposed to use for the search. And part of the reasons is because he feels that it will be stolen. So we have such issues where people who are even in the fashion industry are afraid to bring out some of these ideas. But definitely there is this textile design protection that comes under industrial design. So aside from the fact that they can protect like shapes of bottles, shapes of cartons, etc., they can still protect textile.
Textile
So
designs.
there's textile design protection which can be done under this industrial design. And then the trademark, as you said, is for the name and the logo and the brand, etc. So I said, let
Yeah.
me just say this before I move, before my oga will now comment on it. Mr. Max, Please, you can go ahead to comment on her presentation.
Okay, yeah. Okay, hope you can hear me now.
Yes, sir, we can hear you.
Yeah, so Benny, thanks for that present. So this has become my thank God it's Friday tonic now. So Juliana, thanks for that.
Thank you, sir.
It's always great to discuss IP on a Friday.
Yes, thank you.
Yeah, that presentation was a good one. And on the fashion industry, like I always tell people, there are industries you can actually highlight. Those industries, the whole industry is going to collapse like a pack of cards. So I always talk particularly about for instance, the pharmaceutical industry, where IP forms the bedrock of of all research and development. People put money in those industries only because they know that when they come out with groundbreaking drugs, they would at least have the patent rights to monopolize that drug for at least 20 years to recover the investments they are putting to R&D, and then to also make a decent profit for their efforts as well. So the fashion industry is another industry where IP plays a huge role. It may not be as significant a role as it plays in patents. For Benny's touched really well on some of the reasons why there's a cost element. So when it comes to the fashion industry now, fashion is also is seasonal. It flows along with trends. So in pharmaceutical industry, for instance, diseases are diseases and they take a while. So it's something that comes this season and then by next season there's a new disease and all of that. I mean, we have had the same malaria for God long. We are still battling it. Pharmaceutical companies are still coming up with new drugs and new treatments for the same old malaria. So because of that, there's a shorter cycle when it's to fashion industry. So it means what is fashionable this season, by the time summer comes or the fall comes or they have a new fashion show in Milan, that is no longer the trendy fashion. And when we look at patents now, particularly as a tool for protecting or designs, as it were, because that's more relevant to fashion products, the length of time it takes to get a protection, fill your forms, go have examinations in countries where they do substantive examinations. In Nigeria, for instance, we don't do examinations. So whatever designs you take there, the registry is just going to stamp the documents and give it. So it means that actually, if you are banking on designs law to protect your fashion products, then you might have difficult tasks there because by the time you are done getting your design registered, it might already be out of fashion. So that could actually be a drawback in using IP, particularly designs to protect fashion products. And then I'm glad she also mentioned copyright. The why copyright is one of the better ways, to an extent to protect designs in fashion would be because copyright arises automatically of your fashion product at the Copyright Commission in Nigeria. And I know in other countries it's also largely the same. But again, like Juliana highlighted, sometimes it's you have laws, but then there's difference in design here, difference in the fabric used there, difference in maybe the cut of the neckline, difference in his short sleeve or his long sleeve. So there can be a lot of variation. So sometimes doing a copyright application for each of them or a voluntary deposit for each of them could be expensive. But the good thing about it is that what we know about copyright is that all you need is just evidence to show when your work was published or it was you created it. So one clever way to do it in the Nigerian context would be to simply create a catalog of those designs and register that catalog as just one document, or sorry, do a voluntary deposit. So that way you have ironclad evidence of the date that your fashion designs were published. That becomes an easy way. But like I tell people, another easy way to do it is by publishing it on your social media handles, on your website and all of that. That also becomes a timestamp that is also valid. Because what the law simply is evidence to show when was this design published. So if I have my design, the designer has a design, we go to court, then it's a simple matter of who published the design first. So if I could show that on my website through credible analysis of my website, it shows the timestamp that these designs and these pictures came up, on the 1st of January. And Juliana shows that, okay, look, our own design on the 10th, then it becomes easy to prove. Because if you go with your voluntary deposit certificate from the Copyright Commission, it's only evidence, just like any other piece of evidence, like the website, that evidence would do. So all the law wants is just who first, had a copyright in that work. So from that viewpoint, copyright become a more veritable tool, at least an easier, a cheaper, let me call it that, a cheaper tool to prove your copyright in fashion work. So that could be an advantage, but again, as mentioned, sometimes that may not be enough, because I think I heard Benny say that clearly, that when it comes to copyright, really, what, for instance, copyright in the difference between copyright and industrial design when it comes to artistic works is the fact that copyright doesn't protect a mold or something, a sample you do to produce many samples. So, for instance, you've created a mold or a pattern that is using to cut out the designs to multiply them. At that point, copyright that value to protect that mold or to protect the final product made out of those designs you have cut out. So at that point, you actually need industrial designs to do that. So these things can have subtle shades here and there. But overall, it was a good presentation. I enjoyed it, and I think it was good to throw a spotlight on fashion in this context. Thank you.
Okay, thank you very much, sir. So another thing I wanted to point out is the duration. So another reason why people might do both of the protections, that's the copyright and the industrial protection design, is because of the duration. So while one will last for 5 years, that's 15 years, that's in Nigeria, the other would last for either 50 years or your lifetime and 70 years after. I'm not sure which one, because I know some of the copyright protections last for 50 years, while some last for your lifetime and 70 years after. So it depends on where this will fall, but that's part of the reasons why people also merge this to like elongate the time that it has. So despite the fact that fashion is evolving and everything, people might still so if someone is creating like laces or designs like this, not just the style, but something that can last through different seasons, they might also want to go through that industrial protection design. That's the textile design protection. Um, there's something else I wanted to mention. I can't remember, but that's fine. Thank you very much, Bernice. So let's move to. Okay, Clarice will not be able to do her presentation, to give her presentation today. So let's move to Christina.
Good evening, all.
Good evening.
Yes, my presentation today is on the African Continental Free Trade Area and intellectual property. This presentation was actually inspired by Mr. Folari last week when he said he would like to see someone present on this. So I'm just going to do an overview about what the agreement is all about and a little bit on how it relates with intellectual property. So the agreement establishing the African Continental Free Trade Area, it seeks to bring together the African countries to establish a single continental market where goods, services, and people can move effectively, expanding inter-African trade across the continent, enhancing competitiveness, and supporting economic transformation in Africa. So the process of this agreement are in two phases. The first phase is they've been completed, while the second phase is it's on that's where it has to do with intellectual property. It would have been completed by January 2021, but due to the COVID-19, this part of the negotiation was delayed. And the basic objective of this agreement is to create a single market for goods, services, facilitated by movement of persons in order to deepen the economic integration of the African continent. So the effective protection and promotion of intellectual property rights are part of this agenda. And this intellectual property is provided for in Article 4 of the agreement. So since Africa is made up of developing countries, most of that's developing countries and least developed countries. So this intellectual property right protocols is going to offer the African Union member states an opportunity to develop an intellectual property framework that addresses the specific development needs and interests of Africa. And intellectual trade is going to involve international trade. That's where there will be a lot of countries will be trading among themselves. And international trade here, it's more about, it's more than moving of goods across borders. It's going to involve innovation, creativity, branding, among others. And this will also promote innovation and enterprise through the protection of the intellectual property rights of African entrepreneurs. So the agreement is going to the agreement states that the opportunity to prioritize areas of comparative advantage for African countries in an international IP instrument. Furthermore, this um this is going to be used to promote intellectual property rules and standards that are calibrated to the continent's level of industrialization and in line with the AFCTA's objectives. So the intellectual property rights should therefore be complementary and not detrimental to individual national efforts at development by becoming a veritable tool for economic growth. Since we already know that intellectual property rights are they are territorial in nature, so what this intellectual property right will do is going to be complementary. It's not going to destroy what is already on ground in each nations. Next week, I intend to look at the area of how this is going to, that's the specific provisions of intellectual property. That's what should be expected in the area of intellectual property and how it's going to relate with medium and small scale enterprise, because that's the highest employer of labor in Nigeria and Africa as a whole. I intend to look at that next week. And this is also going to serve as a catalyst for technology transfer, technology division, and the economic transformation of Africa's economic from one that is primary resource based to one that is driven by knowledge, information, and ideas. And this is also going to serve as a stimulus package also for Africa post COVID-19 pandemic era. This was stated by the Secretary General of the African Continental Free Trade Area. And also some international organization has actually agreed with this, that is going to serve as a stimulus package for the African continent. And finally, this has a significant potential to serve as a catalyst for African post-COVID pandemic recovery, as I've stated earlier, is going to be an important vehicle for realizing the Pan-African vision of regional economic integration and structural transformation of Africa's economy. So the IP, how that's the Intellectual Property Right Protocol, can help the AU member states to ensure that IP policy is applied in a manner that is supportive of Africa's developmental goals. Thank you.
Okay, thank you, Christina. So two things came to my mind while I was listening to your presentation. One is registration, that's protection of intellectual property. So, for example, the EU states or the EU countries, when you want to do your registration, maybe if you are going through WIPO to like conduct an international registration, once you click on the EU space, like it covers the EU countries. But in Africa, we have a repo for the English speaking African countries, and then we also have another one for the French speaking countries. But even if you tick probably a repo during your registration, you still have to do like the individual countries, etc. So this this presentation that you just did now, I'm wondering how the protection of IP is going to be, whether it will still be an individual country thing, or if they will now have something that will bind all these African countries together so that it will be easier for people to do their registration without having to um, do the registration in separate countries. And then IP registrations are also territorial normally. So that means that even if it's registered, let's say in Nigeria, someone else can be using it in another country. So all these things are things that we would also have to look into. I think these are the two things that came to mind during your presentation. So I'll hand over to Mr. Max to,
Okay, can I say something, please?
okay,
I think while I was doing my research, I realized that in Africa, that's before this agreement, there's no really a that's like an agreement that binds us together as regards intellectual property. So even the ARIPO you talked about, there are some countries that are not part of it.
yes.
So and I think one of the things that the agreement intends to do is to make sure that the African continent have one law that binds together. That's what the agreement intends to do. I'm going to look at that. I'll treat that next week, as I said earlier. That I'm going to treat that next week, and how that's that's I read through some of the laws. ARIPO was part of it. It does not bind all the African countries together. There are some countries that are not part of it. So that's
But
just
is
what I wanted
Nigeria
to
a
say.
signatory to ARIPO?
I don't think
Do you know
so.
if Nigeria
I
is a
don't.
signatory?
You said?
Do you know if Nigeria is a signatory to ARIPO?
Yeah. Since you already said it's English speaking, so maybe, but I'm not sure if Nigeria is signatory to it. But I know Kenya is.
Okay, okay. Thank you. Mr. Max, over to you, sir.
Yeah, okay, yeah, thank you for that presentation. As usual, I'm really impressed because, like I tell you guys, when I started in IP, I started right at the basement. So when I see people really getting things, because some of these things you are discussing are really the high-end and very complex areas of IP. So if you see me always praising, you know that I really need from, I mean it genuinely that, for me, I'm really impressed that you guys have picked up so quickly and are really very passionate and interested in IP. So yeah, you've touched a very good topic, which is the AFCFTA, that's the African Continental Free trade area agreement and it's the IP connection it's going to have. So just to lay a quick background, that when it comes to IP, really, what happens is that IP, in a sense, beyond being individual rights that people hold and people or individuals or businesses hold and use as part of their strategy in business to leverage and create more income, protect their assets, and essentially become more profitable as businesses. There's also the viewpoint from where IP becomes an enabler of the economy. Therefore, at that level, IP becomes a national issue. It's now an issue for national concern, because if the companies in your country are working and are protecting their IP properly, particularly in the international context, using the available international mechanisms to ensure that when their goods and services get to other countries, competitors are not able to take advantage of them because their IP is properly protected. It means that at the end of the day, you have companies in your own country that will be a lot stronger, earning foreign, currency for you. So essentially, they are able to go into other people's countries, play in their markets, and repeat money back. So in that sense, you see that IP becomes a tool for, it becomes a tool for national development. So it's beyond just the individual company or individual involved as an owner of that IP asset. So what that means is that countries or territories are interested in ensuring that their own markets are significant from an IP point of view. So what it means is that, for instance, when you go to the Chinese market, because Chinese market is huge. I mean, you have, a 1.3 billion people with really high purchasing power. It means that as a brand, when you go into China, you are very interested in protecting your IP because you know the value of it. You know that if my IP works in China, then it means that I'm able to monopolize, in quotes, the market that is available to 1.3 billion people. But when you come with that same IP to a country like, no disrespect intended, but one of the smaller countries, let me just even say Nigeria, for instance, as comparative to China, for instance. In China, you have 1.3 billion people who have a lot of spending power. So let's say the brand McDonald's goes to China now. That brand is really interested in, nobody else should be able to copy and steal, from the potential income we can make from this 1.3 billion strong market. But you say McDonald's comes to Nigeria, you have maybe a 200 million strong market with not as high purchasing power. The interest in protecting their brand, and it means that in terms of the Nigerian government and the Nigerian economy now negotiating with McDonald's, we have less bargaining chip, because the worst that can happen is McDonald's say, look, we can even do without your market, which is what's happening now. There's really no McDonald's in Nigeria yet, because they just feel certain things in the market or certain things are not right for them to come into the market. But if it was China, for instance, they'll be more anxious to go there because of the higher level of bargaining power, meaning that when they are coming to Nigeria or the Chinese market, what they are willing to spend on protecting their IP in China will depend on what they are willing to spend to protect their IP in Nigeria. So another good example is that in Dubai, for instance, registering one trademark, just the fees, the government fees alone is $3,000 just one trademark. But whereas if you come to a place like Nigeria, registering one trademark, even plus the attorney fees, tops, maybe what, $200, maybe $150 tops would be what it would cost you to do that. That's just because the Nigerian market is not as lucrative as the Dubai market. So it means the Dubai government is making a lot of money from trademark registration. So I'm saying all of this just to set up a background to show why, the AFCFTA is important. Africa coming together as one power block when it comes to intellectual property is actually important. So Juliana, you mentioned rightly that when you go to if you want to use the Madrid system or the PCT, for instance, to designate Europe for your patent or for your trademark, let me use trademark, the Madrid system, for instance. You want to register a trademark and you want it to be protected in Europe. So you now select the EU. Automatically, all the 27 now, that's minus Brexit now, that's 27 EU member countries are covered by that mark. So it means that for a brand who is looking at going into Europe now, that becomes a critical market because you have 27 countries with purchasing power. But when it comes to Africa, like you rightly said, you have to designate each African country separately. So for most brands, then I say, is it worth the stress to now have to deal with 54 different applications in 54 countries in Africa, rather than having Africa come to background to the argument for having Africa to have one IP system that's just a lot more bargaining power. But now coming to the specifics of it in Africa. So at the moment in Africa, we have 54 countries, so all the 54 countries have their 54 different IP systems. However, some of the countries have come together in two groupings. So there's the ARIPO now, which has at the moment 19 countries who are mainly English speaking. So yes, Kenya is one of them. Of course, Zimbabwe is, that's where the headquarters is located. But the interesting thing is that neither of the two giant Anglophone economies in Africa belong to ARIPO. So Nigeria is not a member of ARIPO. South Africa is not a member of ARIPO, sadly. Then we have on the other side OAPI. OAPI is dominated by the French-speaking countries and is headquartered in Yaoundé, Cameroon. Now, OAPI is different from ARIPO. In ARIPO, what ARIPO is essentially, ARIPO is a filing system. It's not an IP system. So it means that when you use the ARIPO system, the individual trademark law or patent laws in each of the ARIPO countries is still at play. We are not approaching it as one IP law that is applicable in all the 19 countries. So that's one disadvantage of the ARIPO system. But OAPI is closer to the EU system, where they have a proper IP system. So it means that if you file an OAPI trademark, automatically that trademark is immediately enforceable in all the 16 or 17 countries that belong to the OAPI. So the OAPI block, Cameroon, all the phone-speaking countries in West Africa, so Cote d'Ivoire, Senegal, Benin, Togo are all part of the OAPI system. By the time you add up the countries in the OAPI system and even the ARIPO system, you have about 37 or so countries, 16 in one, I think 18 or 19 in the other. But it means that we still have a huge chunk of African countries outside of the framework of these two. So what is currently ongoing is that in the AFCFTA, the first part of the AFCFTA has been negotiated, but the IP, the protocol on IP has not been negotiated in the phase 2 of the negotiation. So if you, I'll just give the assignment to you guys, just Google it, the phase 2 negotiations of the AFCFTA. So IP, competition law and all of that are all part of that phase 2 negotiation. So it's ongoing at the moment. One of the proposals on the table is to create a Pan-African intellectual property office, which relates ARIPO and OAPI, and then have, hopefully, all African countries sign up to that one IP system. And then from there, we can work gradually towards unifying the IP system, just like the EU. One IP application, one trademark application, one patent application would cover all, Africa. But however, I just want that to show if that would work. And sometimes part of the problem is actually, with due respect, just that now the individual IP practitioners in these countries do not want one system, because what it means is that if we have one system, then it becomes equal for the IP guy. I mean, because at the moment now, if anybody wants to do an IP registration in Nigeria, he has to contact a Nigerian lawyer. But the Nigerian lawyer is wondering if there's a PIPO, for instance, maybe the PIPO is based in maybe Nairobi or maybe based in Addis Ababa. So he's wondering, look, that will cut me off the market. I mean, the person just goes straight from New York, he contacts PIPO or contacts a PIPO accredited lawyer who has the advantage of that, or in Nairobi, and he does his registration, and then I'm cut out of the loop. So that is part of the challenges we think we're having, and why it may be difficult to get a uniform Pan-African IP system. So it's a discussion that is still ongoing. The negotiations are ongoing, but we hope that at the end of it, we'll begin to have something closer. And then more importantly, why having a uniform IP system would really benefit Africa is that beyond the traditional IP, which is trademark, patent, copyright, and industrial designs, we want an IP system that addresses some of the unique things that Africa needs to have. Traditional knowledge is one of the things that Africa needs to come together and address. So other countries have used, for instance, geographic indication, but money has to be. France, for instance, makes a lot more money from the sale of wines, which is protected by geographical indications, than Nigeria makes from the sale of crude oil, or Angola makes from the sale of crude oil. So if Africa comes together, non-traditional IP areas, it would be very beneficial to Africa. That discussion succeeds and Africa is able to come together. Thank you.
Thank you very much, sir. Very extensive and very educational. Thank you, sir. So let's move to Tony. Tony, you can make your presentation. Oluwa Tony Adekunle. Okay, so if you're not yet ready, then let's move to Michelle.
Okay. Good evening, everybody. Should I still share my screen? Okay.
Please do. It would be good if we all try to share our screens when we're presenting, so that even if someone is listening to it sometime in the future, they can always follow your slides.
Okay.
Thank you, Michelle.
So my report was on intellectual property infringement. To be precise, trademark infringement. Starting with the definition, trademark infringement is the unauthorized and illegal use of a trademark without the consent of the proprietor of the mark, whereby it is used to cause confusion between the original mark and the mark use. So the main thing with trademark infringement is that if there is a mark, the other mark which will be said to be infringing must be one that would cause confusion in between amongst consumers or customers. For example, now when they see the two marks or they see the two designs or they see the two products, they will be confused. When that happens, you can see that there has been trademark infringement. A registered trademark grants to the proprietor a right to institute an action in court for the infringement made on such a trademark. But in the case of an unregistered trademark, the owner may institute an action for passing off made on his mark. Section 5(2) of the Trademark Act states that, let me just read it, without prejudice to the generality of the right to use a trademark, the marks shall be deemed to be infringed by any person who, not being the proprietor of that particular trademark, uses a mark that is identical to it or that resembles it, just as I stated above, that it is now so likely to cause confusion in the market or in a store. For example, they are side by side and a consumer does not know the difference between the two because one person has copied the design, copied the name, copied maybe the color, copied how it looks, copied anything about the other trademark. An infringement of a registered trademark cannot be maintained unless the court finds that the defendant is engaged in the use of the mark, which is okay, as stated already. The owner of a trademark who wishes to enforce his rights can explore the following. Can file for opposition within 60 days of the publication of the trademark or publication of that trademark in the trademark journal against the registration of that similar trademark, which is likely to cause confusion. The owner can also enforce its right by writing a cease and desist letter to the infringer. So perhaps you go to the market and you see a product that is quite similar to yours. If you are able to contact them, you can. Although I don't know how much good that's going to do. In Nigeria, the protection of intellectual property rights is defined and regulated by several statutes: the Copyright Act, Patent and Designs Act, Trademarks Act, and okay, as also stated, the courts are responsible for finding for protecting that trademarks and for protecting that your intellectual property, whichever of them has been infringed upon. Where a brand name or a trade name is not registered, it can be protected by the thought of passing off. So the claimant can bring an action for passing off. It provides the protection of an established trade goodwill already acquired by a trademark or a trade name. The most important thing for the action of passing off now is the burden basically is on the claimant to prove that you have such goodwill in your particular product that anybody else that comes with a similar name or a similar look is actually going to be taken away from your goodwill, perhaps in a financial manner or in a reputational manner, maybe doing something that is subpar, and then consumers begin to think that is this now their new, maybe this is the infringing product is of a lesser quality. People now begin to think that your product is now having a less quality. You have to be able to prove that your goodwill, the goodwill you have in that product is so obvious and so influential that when your product is copied, there's going to be severe or significant damage to your brand or to your product. Infringement actions that could grant an action in passing off includes the misuse of trade names, trademarks, or the design outlook of the goods or the business in question. In the case of Niger Chemist Limited versus Nigeria Chemist, the plaintiff sold drugs as chemist in Onitsha, Eastern Nigeria, and the defendant, who I believe is Nigerian Chemist, yeah, so Niger Chemist sold drugs, and Nigeria Chemist opened a shop on the same street and started selling drugs as well. When they went to court, so the claimant went to court, the court granted an injunction against the defendant on the basis that the use of the name Nigeria Chemist was intended to deceive the members of the public to believe that they had some sort of relationship between them. The names were similar and the business that they were doing was very similar. When it comes to the actual action of instituting actions in Nigerian courts for passing off, there's the issue of the appropriate courts that has jurisdiction over such matters. This is especially so when the alleged breach and cause of action emanates from an unregistered trademark. I think this is one of the main questions I have for Mentor. When I was researching, I saw this a lot, and I do not understand if it is a trademark. Is it that they're not sure of the courts for the trademark infringement action or for passing off? That's one of my questions. Another of my question also is Ms. Juliana mentioned something earlier that in Nigeria, trademarks do not have to be registered. So it's not a compulsory thing for your trademark to be registered. So in a situation where your trademark is registered, can you still bring an action for passing off, or can you now try to enforce the trademark act? I'm done.
Okay, thank you, Michelle. Very, very nice and very good presentation. So, yes, you can decide to register or not register, but it's more advisable that everyone who has a trademark goes ahead to register it because it's easier to actually enforce if your trademark is registered than if it's not registered. So if it is not registered and it's not even a popular name, so if like a brand like Coca-Cola is not registered because they are notorious and people know about them, they can just go to any court and say, oh, that this person is passing off on them. So there was someone that I registered a trademark for. He had just gotten to the acceptance stage. And then by the time they published it, what happened was that there was a popular brand in the US, or there's a popular brand in the US that has a name that is similar to that. And so what these people now did was to get a lawyer in Nigeria and write to us here telling us that that name is similar to their name and that even if it's not registered, that it's something that is popular and is notorious and people know about it. So if these people should go ahead with their registration, then it will be um, causing confusion in the minds of the consumers. And so we now had to, that's at the publication stage, because when you're doing a registration, there is a there is a search, the acknowledgement, the acceptance, and then publication in the journal before, if there's any opposition, it will be um, brought to your notice before they give you a certificate. And so they now requested that we come to the trademark tribunal. So that's also one of the ways of solving trademark issues, going to the trademark tribunal to then say, okay, this is not so similar, this is in a different class or something. Though for that particular one, it was in class 41, that's the class for entertainment, and the foreign trademark too was also under entertainment. So they were like that this would definitely cause a confusion between their mark and our mark. But it's so what happened at that point was that my client didn't have the funds to even proceed to the trademark tribunal and all that. But I'm just trying to say that it's easier when you have a registered trademark than to go through the unregistered route. That's if it's not even popular in the first place. Then yeah, so you were talking about like the cease and desist letter and the courts and everything. So I wanted to add the trademark tribunal also to it. So I think Mr. Marx can touch on the jurisdiction, but I think generally for IP issues, it's in the Federal High Court generally. But let's Mr. Marx talk about it. Thank you, sir. Thank you, Michelle,
Okay,
too.
yeah, thanks, Michelle, for that presentation. Yeah, and trademark infringement actually, yeah, I mean, Juliana, even looking back to our talk on Friday last week, on infringement, because when it comes to IP, like I tell people, the real deal actually is infringement. Registrations and all of that is fine and good, but after you've gotten your registrations and all, how do you really ensure that your IP right actually yields, what it should yield? So infringement actually becomes where your IP right really tells, it makes the difference for you. But a lot of times, I think people don't pay enough attention to infringement, and because of that, and even when there's an infringement, there's a lot of questions and arguments, because once there's an what infringement, you determine what right exactly was infringed. And one thing we always bear in mind is that when it comes to IP infringement, sometimes it's not just going to be very straightforward. It could be one infringement, but there'll be multiple rights infringed. So I'll give you a simple example. For instance, I've decided to, maybe I'm a book publisher, and my name is Everlaw Book Publishers Limited. And we find out that somebody has gone, and we've published some books. Maybe Juliana has written a wonderful book on IP law in Africa, and she has given us the rights to publish that book. We publish that book, and we go ahead and print the books, and then suddenly we hear that someone, maybe Michelle, has gone to a printer in China to produce 10,000 or maybe 1,000,000 copies of the books. And having produced 1,000,000 copies of the books also, beyond copying the books, the packaging of the books, which includes the logo of Everlaw Publishers Limited, is also included in that book. And they are bringing them into Nigeria. And then maybe in addition to that also, we have put a unique anti-counterfeiting measure in the book. So for instance, we have put a unique strip that when you buy an original copy of the book and you scratch that strip, it turns to a particular color to let you know that, okay, indeed, this is the original copy of the book you have bought. And then Michelle got the counterfeiters in China to do exactly the same thing. And they have imported, and they have made the copies and importing them into Nigeria. And I get to the Nigerian customs. Now you can see that this is one infringement, but there are multiple rights involved. So the book itself is a copyright. So there's copyright infringement involved. The logos that they have taken is a trademark. So there's trademark infringement involved. The unique strip that tells you whether this book is original or it is fake is a patent, because we have protected that with the unique technology. We have protected that with the patent. So you can see that there's also a patent infringement involved. Then beyond that also, it could also be possible that the packaging that they have used, even though we don't have a trademark over that packaging, but there's a unique packaging, colors, and a combination of maybe holograms we have put on that book that makes it look unique. A usual way that Everlaw publishes logo and colors and hologram. So all of these have been infringed. For instance, it's not a registered trademark, because maybe, for instance, the law in Nigeria doesn't exactly seem to recognize registration of holograms as trademarks, because some of those holograms look like it's a moving image. It's not exactly a still image. So that could be a challenge in registering it as a trademark in Nigeria. So imagine all these things have happened now. It is one event, but multiple infringements. So what now happens is the question of jurisdiction comes in, and where it becomes a little tricky now is, now under the law, for instance, under Nigerian law, and I believe, okay, Kenya is not like this because Kenya is not a federal system. Clarice, you let me if I'm wrong, but I believe run a federation. So there's just one country has provinces or regions for administrative purposes. Nigeria, where we have each state has its own separate legal system. There's a federal system, there's a legal system for each state. So for instance, in Nigeria, each of the states have their own high courts, separate from the federal high court. So between the state high courts and the federal high courts in Nigeria, each court have competencies, what kind of cases they can handle. So for instance, the trademark law in Nigeria is a federal law. So if there's a trademark infringement, only the federal high court can pronounce or look into a case of trademark infringement, because trademarks are registered federally under the Trademark Act, which is federal law. Same thing with patents. Patents and designs are also registered Patents and Designs Act, which is a federal law. Therefore, any infringement goes to the Federal High Court. Same thing also with copyright, at that level. But passing off, which, for instance, infringement that happens when it's my logo and the unique packaging that we use for ballot books. Passing off is, in that sense, covered by the Trademarks Act. Therefore, the state high courts in Nigeria are the courts competent to decide questions of passing off. So the question comes in at this point now: which court do I approach? Since passing off is a state high court matter, and trademark, copyright, and patent infringement, which are also implicated in this case, are federal high court matters. So go to the federal high court, do I go to the state high court, or do I split up my case, take part of the case to the federal high court and take part of the case to the state high court? So that's where the confusion comes in. The position of the law as it stands is that when it comes to that position, now the federal high court has exclusive jurisdiction. It means that any issues that the federal high court has the competence to adjudicate, no other high court can share that that right with it. So because of that, the increasingly in Nigeria, they believe the position of the law seems to be that you rather go to the court that has the exclusive jurisdiction. So in this case, you take your case to the federal. So is that you cannot split up a cause of action. So in this case, your cause of the importation into Nigeria infringed on my IP rights. So you can't split that infringement and go to different courts, because the fear is that there's only two courts to come to different conclusions, which would now be, contrary to the law. So because of that, you should go to one court. So that's where that challenge comes in, that do I go to the federal court, go to the state court? Like I said, for now, the law seems to be that increasingly go to the federal court that has a special jurisdiction to be able to decide, issues of trademark, copyright, passing off, and all in one. Then another place where this argument becomes important is, for instance, in the law of franchising. So if I take a McDonald's franchise includes a lot of things. They are giving me their trademark to use. They are giving me some of their trade secrets, which include their secret recipes to use. They are giving me their copyright, which include their menus. They are giving me their patents, which include some of their recipes that have been patented. So imagine having all of those rights. When I have okay, you're still muted, Juliana.
Okay. Sorry, I think that the network was a bit poor at some point. So when you mentioned McDonald's and the rights that they give out in the license or in the franchise, that was
Yes.
where we lost you.
Oh, so let me take that again.
Yes, sir.
So essentially, I'm saying that in a franchise that gives a bundle of IP rights to the franchisee to be able to run the business exactly in the same format. So that's the owner of the IP rights. So if McDonald's is giving you a franchise, now they are giving you the right to use their trademark, their get up, the seats, the colors, and all of that, which would be to an extent issues of passing off. Number 4, things that secret recipe.
Is it just my network or
Could actually have been okay.
She's breaking.
Can anyone else hear me?
just breaking right?
Yeah.
Sir,
Maybe you can turn off the video.
will it help? Sir, please, your line is still breaking. That's your connection is still breaking. So we're not still hearing you clearly. Hello, sir. Okay. Maybe maybe when he comes back online, that's okay. Maybe when he comes back online, he will just complete his train of thought. But generally, a franchise is like they give you like a package. So they give you the trademark, if that's like all the protections that they have, including their trade secrets, their manuals, their methods, etc. So I think he was trying to explain something that would have to maybe link it back to um, trademark infringement, etc. So maybe when he comes back, he will explain where he's trying to head to. So so I don't know if we should just move to Tony, but I can see that there is a Daniel here. Hello, Daniel.
Hello, ma. Good afternoon.
Okay, good afternoon. I think I gave you the link last week for the um, sports presentation.
Oh, I didn't really check through. I'm sorry.
Okay,
I didn't
but
really read
you
through.
just noted the time and joined us.
Yeah, I just noted the time and joined.
Okay.
Maybe next week I will be more prepared now.
You said?
I said maybe the next session I will be prepared for. I don't know if I'm giving a topic, but I just noted the time
Don't
and
worry,
just.
we will actually discuss after this, because when I saw Daniel, I had to go back and check my LinkedIn to remember that I gave you the link for the sports stuff. So it's fine. Let us chat after this.
Oh, okay, ma.
Okay, thank you. So, Mr. Max,
Okay, hope can you hear me better now?
yes, sir. Sorry, I think part of the network used to
Okay,
fluctuate
apologies.
when we are moving our hands or something, so it affects it sometimes, movement of the hands. So I'm just guessing maybe that's part of what affected your
Okay, that
network.
I suspect that's possible. Okay, but is it better now?
Yes, sir.
Yes, sir.
Okay, thank you. Yeah, okay, so I'll just take the McDonald's part again, just because I believe it's an important point. So essentially, I'm saying when McDonald's gives you a franchise, they are giving you a bundle of rights. So there would be copyright, for instance, because they are giving you the permission to reproduce and use their menus. That would be copyright. They'll be giving you the right to use the McDonald's logo and McDonald's name, which of course will be trademarks. They'll be giving you the rights to use their business dress, which is how the shop looks, the seats that you use, the color, the cutlery, the tables, the arrangement and all of that. So that would be passing off issues. They'll be given the rights to use their secret menus. That'll be trade secret. Of course, even things like their accounting formulas and all that would also be trade secret issues. Giving you the rights to use, for instance, the unique shape of their and other utensils, that extra designs issues. They'll be giving you, the right to use. Okay, I think I've talked of passing off as well. And then they'll be giving the right maybe to use some of their unique, maybe for instance, the seasoning they use to make meat tender, which could actually be protected by patent. So they are giving you the right to use all that, that bundle of IP. So it's not just one IP right they are giving you in the course of that franchise agreement. So if you have a dispute arising from that franchise agreement, then the issue of jurisdiction becomes important. Right, then to make it more complex, let's assume part of it is also touching on the conditions of employment of the employees. That now means that you also now have a case where the industrial court, the National Industrial Court in Nigeria, is also implicated in the matter. So you now have to ask yourself, which court do I go to? Since this issue borders on, the exclusive jurisdiction of the Federal High Court, the National Industrial Court, or State High Court. But like I tell people, when it's an IP issue, your safest bet once any of either copyright, trademark, patents, or designs is involved, go to the Federal High Court. The Federal High Court should have the competence and the jurisdiction to determine all the other issues, even including issues that are not exactly within the exclusive jurisdiction of the Federal High Court. Thank you. So I hope you got that clearly.
Yes, sir. Thank you.
Yes, sir.
Okay.
Thank you very
Thank
much.
you.
So we'll just call on Tony. Tony Adekunle, Tony, if you can just give your presentation quickly. Okay. Um, okay, so I don't know what's happened. Um, So I think we'll just give her 2 or 3 minutes. If she's able to come back and join us to make her presentation, or if she's not able to, then we'll leave it until next week. Clarice is on the road, so she will not be making her presentation because she said that her background is noisy. But does anyone have any extra questions so that we can handle that maybe in 2 to 3 minutes before we log out? If Tony is not able to join us. Daniel, do you have a question? Christina, Clarice, Michelle, Bernice, does anyone have any question?
Okay. Sorry, Ma. I think I have a question. It's
Okay.
on, although, yeah, an interesting area to me. It's on after and intellectual property because, like, it was rightly captured that IP, the articles on IP has not been, how do I put it, has not been finalized. And but I just want to ask that once this article comes into force, um, because there will be infiltration of expertise from different African regions. And I remember I heard us mention about something like Afripo, and I can't remember the other regional or sub-regional um, sub-regional treaty. But I just want to ask that, um, is there with this for IP lawyers in Nigeria? What will be when there's conflict now between the treaty and our own IP laws? How would this conflict be resolved? Because that's just my question. How would the conflict be resolved? Once there's a conflict, there might be a conflict. Once we can, once there's a conflict, is there, although it's not yet in force, but once there's a conflict, futuristically, how do we how is it going to be resolved? Is it through dispute resolution, or because looking at the after dispute resolution itself, it only provides for state to state dispute resolution. I don't think there's something like ISDS or dispute resolution mechanism in the after. That's just my question. How would conflicts be resolved when there's a conflict between these laws, between our laws and after? What how are they going to be resolved?
Okay, so I'm just going to, before we respond to your question, Tony, are you ready to make your presentation? Tony, Adekunle, Tony, are you ready for your presentation?
Yes, my I don't know if you can
Okay,
hear me.
please just go ahead before we answer Daniel's question.
Okay, I'm trying to see if I can share my screen.
Okay.
Yes. Okay, so my assignment. Can you guys hear me? My assignment was
Yes.
what is scheduling and its relationship with copyright. So I started with the definition of what a copyright is, which is a right of an owner, which is an intellectual property right vested in an original owner of a literary work, a musical work, a novel, software, an artistic work, or a cinematograph film. And it gives this right, including the right to reproduce the work, the right to prepare derivative work, which is basically like converting of a novel to a movie or a stage play into a movie or just turning the original form into another one, and to perform and display the work publicly. Um, Copyright is protected under the Copyright Act in Nigeria, and it has there are requirements that have to be met for a work to be protected under copyright, which is found in section 1, sub 2 of the copyright. Number one, it has to be original. A work has to be like relatively original or new, and copyright does not necessarily protect an idea. It just protects a fixed medium of an idea, which is like original. It has to be somewhat unique, not a copy of someone else's work. And the second form is that it has to be a fixed medium of expression. It has to be like you can see it. It has to be in a tangible form. You can see it um before it can be protected. Like I said before, copyright does not protect um ideas, but it protects the expression of the ideas. And when it comes to fair use and fair use and fair dealing is the context is which a person uses a copyright work without paying any royalty to the copyright owner, which means that a work will be regarded as being used fairly if they use it for like academics or critique. They want to make a critique on the particular subject, a private study, a parody, or a satire. And for what would be regarded as fair use regarding a particular work would differ in different cases to be determined by the circumstances of each case. Sometimes what the court would determine, I don't know if you guys can still hear me, what the court would determine if what the court would determine, sorry, for a work to be regarded as fair use or fair dealing was what was the purpose of the research? Number one, was it commercial or educational? If a person reproduces a work for the purpose of making profit off of it, I don't think that the court would regard it as fair use. What was the amount of the dealing? Like if a substantive amount of this particular work was copied, it, the court will not regard it as fair use or fair dealing. Alternatives to the dealing, was the work necessary for the end result? Could a different approach or a different work be used for it to be regarded as fair dealing? The nature of the work, is there a particular, is there a public interest that that is vested in that work that would differ you from using that work? And basically, what would be regarded as fair use or fair dealing is a work that, first of all, does not interrupt with the paternity or economic rights of the copyright owner. And if the person uses it in context to like make contributions to a particular subject, like maybe the person is using the work for um like studies or academics, it would be regarded as fair use. Thank you.
Thank you very
Yeah.
much, Tony. You've actually touched
Yes.
a lot of things regarding fair use, and what you said made it made a lot of sense. So there are
Hello.
things that, can you hear me?
I hear you now.
Can you hear me? Can you hear me, Tony? Or can anyone hear me?
Yes, ma, we can.
We can hear you, ma.
Yes, we can. I can hear you more.
Okay, so there are like things that are already listed for things that fall under fair use and this thing, but finally it's still the courts that will determine if it falls under fair use at the end. That's by the time you take it to, that's if there's an infringement and you actually want to determine if this falls under fair use or not. It's still the court that will finally make that distinction, whether it falls into it and or not. um what I want to talk about is derivative works and works that come out of it. So if somebody takes another person's work and they make a derivative work out of it, and they are also getting economic benefits from it, then they cannot call it fair use. So if, for example, it's a musical work and you take someone's song and you do something out of it, and you modify it or whatever it is, and then you put it out there, you are selling, whether you are even selling it or not, you're supposed to just get a license. And those are things that are supposed to be in place before you even go ahead to do all those things. So when you don't do all those things and you then take it and say, oh, I'm not gaining anything from it. For example, there was a classmate of my sister that was playing a song in the background while he was ironing his clothes. And he actually posted that video on Twitter, and Twitter blocked him because they said that it's not the first time that what he's doing, playing someone's song in the background of what he's doing, is that he's depriving the other person of making economical benefits from that person's work. Because instead of someone to go and stream on Spotify or go and download it from iTunes, they might just keep repeating his video, and then it's okay for them. So the person that owns that particular work has now been deprived of what they're supposed to have gained because he's using that. But there are some social media platforms that have ways of monetizing this. So, for example, YouTube will just inform you that the work that you are using is not an original work and that the work is for this person. And so, if that person is affiliated to a monetization system, what they will do is that they will just monetize that video, whether you are monetizing your YouTube channel or not. When it comes to where that song is played, they will just monetize it and make sure that they pay the owner of the song their song. So they won't even disturb you about it, but they'll give you an option to challenge it if you feel that no, this is not their song, this is my song, or I took permission, etc. So these are some of the things that some of these platforms have put in place to ensure that okay, they don't have to start taking people's YouTube channels down or taking people's Facebook channels pages down. They just put all those systems. So they have like a fingerprint system. And by the time you're registering your song, you have like different codes and everything. So once those songs have all those fingerprints, wherever they are put on all those platforms that can identify the fingerprinting system, what they do is just to monetize it without speaking too much English. But those platforms that are not operating on those kind of systems might just take the work down or etc. So it depends, but finally, if you really have to establish what would pass as a fair use or not, you might have to go to a court for a judge to actually say this is fair use or this is not fair use. And then for what Mr. Daniel asked, like I think, for example, if you have a case with if there is like an IP issue, domain name issue, etc., and you want to go to, that's even if you're a signatory to the treaties that are under WIPO etc., you are the one that will apply whether you want to use that system or not, especially if it's an international um, dispute. But if it's within the same country and everything, you might say, okay, I want to start with this, and it might also be in the contract, or if it's not, or if there's no contract, you might say, okay, I want to start with the Federal High Court or something, and then like that. Or you might say, okay, I just want to go through alternative dispute resolution through WIPO. So I'm thinking maybe for the free trade agreement and all that too that is coming up, maybe they might have all those options in place for people that want to resolve their issues in those ways or this, but I'm not sure which um would surpass the other and everything, except maybe for different countries. But I'll just move it to Mr. Marx for him to comment on Tony's presentation and on Daniel's question before we end.
Okay, Okay, thank you again, Juliana, and thank you, Toyin, for that presentation on fair dealing. Fair dealing actually is a hot area of copyright law, because typically what we must understand, and usually when I speak this way, I always try to give us background context as to why the law has some of these provisions. So we need to understand that copyright essentially, of course, gives the owner of, original expressions a right to monopolize economic benefit flowing out of that expression. So you write a book, you create a movie, a work of art and all of that, you have that right. But the society also understands that in as much as that right should be given to you, but sometimes that expression you have created is a necessity to benefit others, or to also bring them to the point where they can also become useful to society and also create their own works that will make society a better place. So that's always the balance I say when it comes to IP law. IP law, the law is always striking a balance. Yes, we want to give you a monopoly to ensure that you are able to benefit from your sweat and your intellectual toil. But at the same time, we also understand that the society has a greater benefit, or a greater what word I use now? Apologies. A greater need to also benefit from the collective innovation found amongst the people. So because of that, fair dealing is one of that exception to copyright, where people are allowed essentially, and just the way the word sounds, fair dealing or fair use, to use your copyright in a way that is fair to you and at the same time is beneficial to society. So fair dealing, for instance, in Nigeria has a special exception, particularly for institutional, for academic institutions. However, there's a catch there when it comes to that section. I can't remember the exact section of the Copyright Act. It says registered or authorized or something like that, or licensed academic institutions. So it will mean, for instance, that if we were trying to rely on a defense under that law, under that particular section now, and I have come to reproduce somebody's copyright work in this mentorship session, and we go to court and say, look, we did this, it was fair dealing because we used it to impart knowledge in the course of the Juliana Intellectual Property Consulting Mentorship class. The question that will be asked now will be, is the JIIPCC mentorship a licensed or registered educational institution? So that's one place we should watch out for when we talk about fair dealing. I've not gone much into fair dealing because to a large extent, Toyin's presentation has very well captured what fair dealing is all about. I just thought to bring that out. I just thought to bring that out. Apologies, because I think that's important. We have that at the back of our mind. That even though fair dealing is broad, and I'm not saying that every context of fair dealing has this exception, but there's a particular clause in the Nigerian Copyright Act that says for academic institutions, because, okay, no, sorry, just to make that clear, academic institutions actually are granted a broader scope of protection than other people when it comes to fair dealing. So I'm just saying that, but however, that enhanced scope of protection is only available to academic institutions where they are licensed or registered academic institutions. Then turning to Daniel's question on how dispute resolution will be conducted at the level of this international law. Say, for instance, the AFCFTA is able to bring together the African IP system. So essentially, well, that becomes a question of what we call private international law, or conflict of laws, where a country has its own domestic laws, and you at the same time ratified international laws, which law supersedes in the event of a dispute between the two laws. I believe that's one of the context of your question, Daniel. If you just clarify.
Yes. That's actually the context of my question.
Okay, excellent. So the answer to that comes from international law, like I said, from conflict of laws. So typically, countries in the world, when it comes to international law, are divided into two broad categories. They are the countries we call the dualist systems. The dualist people, or the dualist system of law, simply mean that the moment those countries sign up to an international law, automatically that international law becomes a part of their domestic law automatically. So it means that they don't have to do anything else before that international law becomes a part of their domestic law. So the moment they sign up to an international treaty, for instance, like the PCT or any of those international treaties automatically becomes applicable in their system. Oh, sorry, I made a mistake. I mean, the one I just explained now, that is the unitary system. So it means that they have one system of laws. So whether there is an international law, a domestic law, automatically they all become part of the law of that country the moment the law signs up to it. Then we have the dualist system. So the dualist system simply says that after a country signs up to an international law, the country in-house, the country's legislature must also enact the same law locally before that law becomes applicable. So for instance, Nigeria belongs to the second class, that is the dualist system. So by virtue of section 12 of the Nigerian Constitution, after Nigeria ratifies an international treaty, the National Assembly must pass a law to domesticate it, to make it a part of Nigerian law. So in that sense, when an international law applies in Nigeria, it's not the international law applying, but it is a domesticated version. That is the version of that law that the Nigerian National Assembly or House of Assembly, as it were, has passed into law locally. So in that sense, there's only that Nigerian version of that law applicable in Nigeria. So it means that Nigeria signing up to a law alone is not enough to now make it applicable in Nigeria until the legislature in Nigeria does the work of domesticating or passing that as a local law in Nigeria. So with that context, okay, and just to give you examples of how this applies. So for instance, there's what we call the Montreal and the Warsaw Convention that governs the responsibility of airlines towards, misplacing luggage of people, in aviation, and then also when there's a aviation accidents, how compensation should be paid. It's an international treaty that a lot of countries have signed up to, including Nigeria. So what Nigeria has done is that after signing up to that treaty, Nigeria passed a Nigerian Civil Aviation Authority Act, and then that international law is now annexed as an annex to the Nigerian law. So what applies in Nigeria is not the raw Warsaw Pact or the Montreal Convention. It is the Montreal Convention or the Warsaw Pact as reenacted in the Nigerian Civil Aviation Authority Act. But however, going further, where there's a conflict between international law and local law, so for instance, there's a conflict between that Montreal Convention and a local Nigerian law, by what they call the Committee of Nations, which is just saying that, look, for respect for international law, you should always allow the international law override your own local law, because by signing up to that international law, you are saying that you have agreed along with other countries to be bound by that international law. So practical scenario of how this plays out now in IP law would be the Paris Convention, or let me use the Paris. Oh, no, I don't use the Paris Convention. I want to use the what's it now? The one on the Berne Convention on copyright, for instance, which is one of the most widely ratified IP laws, which is in essence why we say sometimes that copyright is almost international in dimension. What law says is that, the principle of national treatment. It simply means that as a Nigerian, you must treat a foreign copyright work the same way you treat a Nigerian copyright work in Nigeria. So every right you give to Juliana IMAM as a copyright holder, when she writes a book on IP law in Nigeria, you should also give to a foreigner, Clarice, for instance, who is a Kenyan, when her work comes into Nigeria. So it means that by that principle of national treatment, her work is protected to exactly the same extent that Juliana's law will be protected. So assuming there's a Nigerian law that gives maybe Juliana as a Nigerian the right to approach the Federal High Court and says that for a foreigner like Clarice, before you can approach the Federal High Court, you need the leave of the Federal High Court to permit you to approach the Federal High Court. Then that Nigerian law, to that extent, to being consistent with the obligations that Nigeria has undertaken under the Berne Convention. So the Nigerian courts are enjoined. There's no law forcing them, but they are enjoined to respect that fact and to interpret the law to say, no, Clarice also has the same right Juliana has to approach the Nigerian Federal High Court without seeking leave of court. So it's when it comes to international law, it's not exactly binding, even though there are many ways through which it could be made binding. So for instance, you hear the US issuing sanctions against countries because they have breached international law. But again, those countries would argue that when the US breaches international law, nobody sanctions them. So international law can be like politics. It's a little bit difficult. It has a regime, but the regime is not exactly straight and clear-cut because enforcement is not exactly clear and straightforward in that sense. Thank you. So I hope that answers your question, Daniel.
Yes, sir. It's clarified. Very
Okay,
insightful,
thank you.
sir. Thank you.
Yeah.
Okay. Thank you very much, Mr. Marx. Thank you for always showing up and always being on point with all your comments and everything, for your support, your encouragement. We are really grateful. Thank you to everyone that joined us today. Thank you, Michelle. Thank you, Clarice. Thank you, Christina. Thank you, Daniel. Thank you, Bernice. Thank you, Tony. I think who else joined? I think I've mentioned everybody that joined. Thank you so much for joining us. And for those that also joined using the Facebook Live, thank you too. So we'll be meeting next week, Friday. And I would let you know if you'll be submitting your assignments, or if we'll be having a guest mentor coming to speak to us. I will let you know immediately. Um, Okay, so next week, yes, I can see. Next week, though I will still inform you, I have spoken to somebody that will come and speak on music business and music law. So if you are not, if it's very good that that you learn some of these things. You might not think you need it now, but just listen to it, just in case you might need it in the future. So he will be coming to talk on music law and music business. So I would encourage everyone to prepare for this. But he was saying that he might not be free on Friday, so he would be available on Thursday, which I still said okay for. So Thursday to still be the same time, 4:30. But I would send you people a private message to confirm the date and the time. And he's very good with music law and music business. So I will encourage that everybody tries to attend. And if you would not be able to attend, try to send a message saying that you will not be able to attend. So thank you very much for joining us, and have a lovely weekend. Thank God it's Friday, so I'm sure some of us that are married, we might just go home with our children, but those of us that are single, we might have other plans. So let's stay safe in this COVID-19 era. Thank you very much. Take care. Bye.
Yeah.
Bye, ma. Thank you,
Yeah,
ma.
bye. Thank you
Bye.
guys. Have a
Thank you,
wonderful
sir.
weekend.
Thank you. You
So,
too.
speaker and host. Bye, ma. Bye, sir.
Bye.